there is no doubt that the courts have jurisdiction to decide upon the extent and limits of a prerogative power. All the parties to this case accept that. This court has concluded that this case is about the limits of the power to advise Her Majesty to prorogue Parliament. In judging any justification which might be put forward, the court must, of course, be sensitive to the responsibilities and experience of the Prime Minister and proceed with appropriate caution. If the prorogation does have that effect, without reasonable justification, there is no need for the court to consider whether the Prime Minister's motive or purpose was unlawful. The third question, therefore, is whether this prorogation did have the effect of frustrating or preventing the ability of Parliament to carry out its constitutional functions without reasonable justification. This was not a normal prorogation in the run-up to a Queen's speech. It prevented Parliament from carrying out its constitutional role for 5 out of the possible 8 weeks between the end of the summer recess and exit day on the 31st of October. Proroguing Parliament is quite different from Parliament going into recess. While Parliament is prorogued, neither House can meet, debate, or pass legislation. Neither House can debate government policy, nor may members ask written or oral questions of ministers or meet and take evidence in committees. In general, bills which have not yet completed all their stages are lost and will have to start again from scratch after the Queen's speech. During a recess, on the other hand, the House does not sit, but parliamentary business can otherwise continue as usual. This prolonged suspension of parliamentary democracy took place in quite exceptional circumstances. The fundamental change, which was due to take place in the Constitution of the United Kingdom on the 31st of October. Parliament, and in particular the House of Commons, as the elected representatives of the people, has a right to a voice in how that change comes about. The effect on the fundamentals of our democracy was extreme. No justification for taking action with such an extreme effect has been put before the court. The only evidence of why it was taken is the memorandum from Nicky da Costa of 15th August. This explains why holding the Queen's speech to open a new session of Parliament on the 14th of October would be desirable. The court is bound to conclude, therefore, that the decision to advise Her Majesty to prorogue Parliament was unlawful because it had the effect of frustrating or preventing the ability of Parliament to carry out its constitutional functions without reasonable justification. The next and final question, therefore, is what the legal effect of that finding is, and therefore what remedies the court should grant. The court can certainly declare that the advice was unlawful. The Inner House went further and declared that any prorogation resulting from it was null and of no effect. This means that the order in council to which it led was also unlawful, void, and of no effect, and should be quashed. This means that when the Royal Commissioners walked into the House of Lords, it was as if they had walked in with a blank sheet of paper. The prorogation was also void and of no effect. Parliament has not been prorogued. This is the unanimous judgment of all 11 justices. It is for Parliament, and in particular the Speaker and the Lord Speaker, to decide what to do next. Unless there is some parliamentary rule of which we are unaware, they can take immediate steps to enable each House to meet as soon as possible. It is not clear to us that any step is needed from the Prime Minister, but if it is, the Court is pleased that his counsel have told the Court that he will take all necessary steps to comply with the terms of any declaration made by this Court.